Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
Is the next search on February 28, 2020? 7:44 p.m. How, period, does the FBI find people? And people's misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Welcome back to the Court of Public Opinion. I'm the Recovery Addict. We are back a little bit early because something has happened. We are back. We're back. Give me just a minute to get everything, all my ducks in a row. That music is really loud. I'm just gonna turn this down just a little bit. I'm gonna turn it down like that because we have different music to listen to. It's the kind of case that will keep you up late at night. That is, wondering if a passenger on a bus really should have gotten off when the bus driver told him to or not. It seems like a big deal, at least it was to the writer. The jury has been deliberating for now the better part of this morning, and a little bit less yesterday afternoon. Probably about 4 hours of deliberation in total, and we hear now that finally, after first false alarm, we do, in fact, have a verdict out of Thurston, Washington. We're going to bring you there right now to hear all the happenings as it developed. Let's see. Where are we at? Let's see. Thurston, you there? Oh, we are. Okay. All right, I'm going to move up to the top corner. This little trial, the bus trial, the gift that keeps on giving, has been bizarre and wild and quirky and fun and sad and everything in between. Be up here because of the weird placement of the defendant who's down there in the bottom left-hand corner. We're just waiting for the jury to come back in this trial. The business of the court was being conducted when the jury returned their verdict. They've stopped their other proceedings, and any moment now the jury will be in here, and we will be listening live, well, almost live. This happened a couple moments ago to the verdict. All right, let's listen. There's a key part in here I hope you want to hear. Oh, at least I hope you hear. Let's turn the music off here. Here we go. This is the trial. It started yesterday, ends today.
Take a seat, man. At the same spot you were yesterday. You go ahead and fold that verdict form against itself. Fold it in half. Give it to the Ms. Garza there.
Who?
The new clerk for today.
Oh.
She'll bring it to me, and then I'll read it into the record. You can be seated.
Why do we have a new clerk? I can tell you why. At least make a good guess.
In the case of City of Tumwater versus Kenneth Ray Little, verdict form reads as follows. We, the jury, find the defendant, Kenneth Ray Little, not guilty of the crime of unlawful transit conduct as charged in count 1. So, ma'am, I'm going to start with you. You're juror number 1. And then, is this your verdict?
Yes, it is.
Is this the verdict of the jury?
Yes.
Your verdict, ma'am?
Yes.
And the verdict of the jury?
Yes.
You, sir, this is your verdict?
Yes.
And this is the verdict of the jury? You, sir, this is your verdict?
Yes.
Is this a verdict of the jury? And then finally, not quite yet finally, but you, ma'am, this is your verdict?
Yes.
And this is the verdict of the jury?
Yes.
And finally, you, ma'am, this is your verdict?
Yes.
And this is the verdict of the jury?
Oh, okay, we got it right this time.
So, members of the jury, I want to thank you very much for your attention and time you put into this case. I told you back on Monday, which seems like a lifetime ago, that you should be done on Tuesday. It went a little bit longer than we had thought. I appreciate your patience. I appreciate you all coming back here in a timely manner this morning and resolving this case and carrying it to its conclusion. I now lift all my previous instructions. You can talk with anyone you want about this case now, or not talk to anyone if you don't want to. Sometimes there's a reason why they call this to practice a law, and that sometimes the attorneys like to come back and speak with jurors after the case is over. But given the amount of time that you have, and I'm not sure, I think they might have other business going on in court, so I'm not even sure if they're available. But you're free to go. I'm going to come back there in just a minute. We're going to do a couple things here in court, and then, but you're all free to go. And thank you.
Thank you.
Thank you.
Okay, we're going to stick with this just for a minute because there is a little bit of discussion afterwards.
You can be seated. I'm going to do a judgment and sentence. Was not guilty, remain released with any conditions that was set in this case. Is no longer, I don't even know if there were any other than don't have any criminal law violations, but
she might be.
And that's pretty much that. I'm going to go back and talk to and thank the jurors personally. I don't know whether you folks want to or not. What's that?
May I address the court briefly? I have a couple of questions.
That's the defendant.
Well, there is no sentence because it was a verdict of not guilty. What are your questions?
When I was taken into custody, I was taken with over $2,700 in cash.
Okay.
They converted that to a card without my knowledge or my consent.
I can't.
Get my money
Okay, I'm gonna stop you for something. There's nothing I can do about that. If you had stuff that was taken and needs to be given back to you, that's between you and the whatever law enforcement agency hold those things. I don't.
I was just asking if you were able to issue an order that would return those funds without me having to pay withdrawal fees every time I take it out in small increments to get it all.
No, I there's nothing I can do about that. I'm sorry. Okay. Anything else?
Nothing from the state, Your Honor.
Yes.
He wants his thumb drive.
Video on it? No, that's an evidence. That's got to stay here. What's that?
It just stays in evidence.
Yeah, no, it's an evidence and part of the case, and it doesn't get. That's the end of it. Yeah. Right. You're welcome.
Going over the
I beg your pardon, but I also turned this into
The prosecutor just said to that guy.
Can I get that?
You need to speak with Ms. Rhodes and state about that. The one that was filed in court, that state.
Yeah. I don't have it with me. You have my address. I'll discuss it as part of our case file.
There's something.
That's part of our case file.
It's part of our case file. I don't have it with me. You can have it later. I don't have it with me. All right. And out they go. That's the end. That's the end. Mr. Little wants some of his stuff back. He wants the thumbnail or the thumb drive, excuse me, that has the video because he has a civil suit. I believe a civil suit still pending against the county or the town in this instance. So he wants the back because he's going to use it in the other trial. But found not guilty. Not guilty. He walks free. He's going to get his $2,752 back, but it's given to him on a card instead of cash. It was in cash on him. They took it, converted it to a card so he can make withdrawals, and he's upset about the ATM withdrawal fee. But anyway, yeah, he had $2,000 on him when he was arrested. Fun fact: you can't make this stuff up. Good news: it was converted to Bitcoin. You made some money. All right. That was the fun little case that we watched yesterday in the filler while we were waiting for the verdict in the Collin Griffith case out of Florida, which is still not in. The jury's been deliberating for about 9 hours now. Let's see. Alice. Yeah, give me a call on the burner phone. Let's see. See, I do answer the burner phone when I'm live on the air. I might not be able to take it right now, but when we're watching court, I might either text me on the burner phone. That's the easiest way. That way I can read it without stopping to interrupt, or leave me a message. Sometimes I'll take the call live. Shame on you, says Paul Mack. I heard the verdict music and thought it was the Florida case. I'm sorry. It wasn't. Let's get ready. We're ready to jump back into the trial with the trial in Tennessee, the Boswell trial, which is using the wrong mouse here, which was a really tough case. It's difficult. I appreciate everyone being supportive in chat and
Happy birthday. You look good.
doing all the good things, being nice to each other and all that. So thank you. That makes it a little bit better, a little more bearable with what we're sitting through, and it is tough. All right, so we have, I'm going to try a little bit different, a change up on the feed here to try to get a better picture. All right. The jury, I think they're close to 10 hours by my count. Law and Crime has them at 9 hours and 24 minutes down in Florida, which it's not terribly long, but it is about the point where we would expect a verdict. If it goes longer than today, I'm thinking it might be hung. All right, so we'll be back with Tennessee here in just a heartbeat. So, all right, can I have my thumb drive back? Yes, I'd like to use it as evidence in my civil suit. No, he doesn't get it back. Sadly, hopefully he can get a copy of it, and that should all work out for him. Let me go back to where I belong. I feel weird up here in the top corner. In the Thurston case, that's the only time they've moved the desks like that, so that the defendant was sitting sort of like at a 90-degree angle to the prosecutor. But it's because his hearing-assisted device was actually, it doesn't connect to the sound in the courtroom. It's just like a microphone with headphones. So it just amplifies everything based on where he's seated. And he says you have to sort of be facing it for it to work. Otherwise, the sound waves don't hit it hard enough to be loud enough for him. So that's why he was seated like that. I expect the courtroom to go back to its regular setup. Seemingly, they hadn't changed ever since COVID. I mean, they've had the 6-foot spacing between the chairs in back for years. So I'm pretty sure they'll put the table back. All right, the clerk, we had a new clerk in the case as well. I hate seeing somebody lose their job, but that's a big no-no. The previous clerk told, all I can say is the previous clerk appeared to have told the jury how to decide a verdict in a case. And that's like the worst you can do. Now, she didn't tell him which way to go, but she said to decide in the majority when the verdict was not unanimous at that point. So, Rage Crochet, you need to watch it. That was a crazy case. It's a little wild. Sometimes it's slow and crazy and quirky, but it really developed into a banger there at the end. Gabs, we're waiting on a verdict out of Florida. Let me show you, let's see what Law and Crime down there shows a verdict clock of 9.5 hours. I've got about 10 hours on my rough clock, with half of it coming today and half yesterday, as far as the split of the deliberation time. But we're also waiting for a live feed back out of court in Tennessee. When that picks back up, we'll jump there. I can't do the jury clock because I've got too many things running right now. I've got, we've got, let's see, I can't show that one. I've got my systems tied up with watching many different feeds. As we move along, I probably will be able to, once we stop the verdict watch, or once that's done in Florida, I'll be able to, add some counters and things. We've only had 2 objections in the Tennessee trial, which has been a surprise. Can we address internet ownership? We can, but I need somebody to out the owner. Was it you, Greeners? Usually, if you're asking about it, you're the one who won. Was it you? Who was first in chat this time? Too many buttons. 1,154 buttons to be exact. We counted. It was Greeners. Greeners, congratulations. You being first in chat this afternoon, I hereby sentence you to internet ownership. You're responsible for maintaining and fixing everything IP-related worldwide. So anyone who has a problem with the internet, please contact Greeners, and he'll take care of it for you. And, as long as everything's smooth and running, we won't complain, Greeners. At least we won't. Other people might. So, all right. Had a lovely lunch. Had leftovers. I'm not sure what you guys had. I did chicken strips, and we had chicken strips and fish sticks, which is it's like 2 meats. Probably should have had a veggie in there, but I had a beautiful bottle of malt vinegar, which I love with fish sticks. My family hates it. They'll leave the room. They hate the smell of vinegar. I went to England, I love vinegar on fish, and yeah, they're not a big fan. Surf and turf, yeah, that's what I had. Let's see, leftover T-bone, baked potato. What's leftover T-bone? That sounds really good. Tartar sauce is better. Yes, but I was out of tartar sauce, Jeremiah. I agree with that, though. Love tartar sauce. No salad today. I had a salad the other day. I told you I went and helped my friend pick a lock, because I do lock sport. I love to pick locks. Lock sport is the game of picking locks that are not in use. So you have a lock, just freestanding lock that you have legal right to pick, and it's not securing anything. And I like to do that. I like to pick locks, and I have various hardware to make that possible. I'm old school, so I like to individually pick the pins instead of just use a device that rakes across everything and all at once does it just by sheer luck. But I helped him get into his cabinet, which he had locked, his tool cabinet, and it took about 45 seconds. But that was fun. Afterwards, that's where I was going with the story. Afterwards, I had my daughter with me because she was over seeing his dog, because she likes the dog. And I decided to eat healthy on the way home, so I had a salad. I had a salad sandwich. I had a Big Mac with a large fry. It was healthy. It had salad on it, okay? But it's good fun. Lockpicking lawyer collab. Oh, my goodness, he's so good. I did a couple lockpicking videos on TikTok, which are fun. And yes, it is that easy to open a master lock. He's not kidding. I was going to be a locksmith. I don't know where I put it, but I've got the in North Carolina, there's a test you have to take, and I've got the manual that I was studying to pass the test to become a certified locksmith. But I didn't go that route. As you can see, here I am. Did you get the answer key for the locksmith test? No, I just got the manual. You have to know like the history of locks and the shape of keys. You have to be able to identify keys from their profile, and look at the side view of a key and understand the bitting and understand the various locking mechanisms, the different types of locks, the history of locks, and there's, of course, there's a lot of legal work in there as well. Any movement in the Collins case? No. Mr. Griffith is still in limbo as the jury's deliberated for about 9-10 hours. Oh, making sauteed shrimp for lunch. That sounds I can almost smell it. I love shrimp. I had fridge pizza for lunch today. I love fridge pizza. So good. So good. All right, let me do a quick check here. Awesome. Thanks for the message. Got it. Appreciate your sharing that with me. Sauteed shrimp for lunch. It sounds like a dinner. We're just waiting for court to start back up. They're just a couple minutes late, and any moment now we'll have that for you. right. Hey, how's it going? Jurors are holding out for Collin Griffith. They'll be devastated when they hear about his father. I don't know. I think in that case, the jurors have probably connected the dots. The Florida trial, if the Florida trial is hung, will he get another? Yes. A hung jury is a mistrial, and a mistrial means they have to repeat the trial. They start over. Basically, they back up to jury selection as if nothing happened after jury selection. They pick a new jury, and they start over. So everything would happen again. Even the arguments and motions and things like that, I think some of those would happen again as well. So they just basically turn the clock back. It is very expensive. It costs a lot of money. It's not cheap to pay for everything that happens in court. Obviously, there's a lot of lawyers' time there. There's a lot of bailiffs. There's a lot of personnel in the courtroom, the judge's time, the jury. Jury pay is probably the least of their expenses, but lots of expense would be a retrial. In some cases, when there is a hung jury and afterwards the jury talks and expresses what the balance was, and they might say, "Oh, there was, all of us were not guilty except for one." The prosecutor might look at that and say, I guess I misjudged this. We misjudged this. It looks like the people aren't as upset about this as we are. They aren't as convinced. The evidence says the same thing. For us, it's not worth it because 11 of 12 people didn't agree with us. So they might not refile. They might not recharge or retry the case, but generally it's a retry. Let's see. Did we place a phone call? We just barely, at the beginning of this live stream, Rick, I didn't place the phone call, but we've got some people that did for me. Reached out to the jury, or reached out to not the jury, that would be terrible. That would be like a clerk move. Reached out to the court and was told that the jury was coming back in. They were still deliberating. They just aired the live verdict, and we covered it just a couple moments ago here. So that case is fully resolved. We've seen the ending, and I won't spoil it for you in case you want to rewind right now and watch it, but the verdict is in. Lester, will we be covering Karen Reed? Karen Reed is one where I'm interested in if the trial is different than the first trial. I don't want another trial where we focus on things that are outside the case of the state taking half the time proving why it wasn't someone else. I'd like to follow Karen Reed if there's new evidence, if there's a different fact pattern, especially if the state comes with a different theory of what happened, because I don't think the old theory was possible. But I would be interested then if it's just a rehash, exactly, just replace Lally with the new prosecutor. I wouldn't be interested in following that. I'm not interested in the circus that's developed outside that case. And there's another KR case that we're interested in. That's the Corey Richards trial, which will overlap that. Out in Utah, she's accused of killing her husband. Similar set of facts, only this is with drugs. And it's got plenty of interesting stuff to follow there. No verdict for Collin yet. Not yet, but we're watching. Close to 10 hours of deliberation time for the jury. I think it'll be different. We are watching. We have been following some of the preliminary, the pre-trial hearings for Karen Reed, so that I can get a feel for any new evidence that is coming in, especially if there's new data pulled off those chips in her car. That's going to be a game changer. If there's something like that, I'd be interested in following it, but it would be a very different trial than what we saw before. The lawyering is good. It's top notch. It's the best money can buy. I did an interview with Courtroom Confidential. Tonight we're going to be on with Courtroom Confidential, 8 p.m. Eastern time, 8 p.m. to 8:30, talking about the. Oh, here we go. Hang on. Hold tight.
Judge, it's hearsay. I mean, just flat out hearsay for him to try to put that in.
It just came back mid-argument. Sorry, I'm trying to find the right button here. Too many buttons. Petrified, that's terrible. I don't know what the discussion is here. It's hearsay if they get something in. Whoa, I did not follow that case. The only thing that interested me was the fact that it was Justice Cannoni. Judge Cannoni. And I didn't follow that one, but she has not guilty in her repertoire. So that's a possibility. That was a bench trial, right? Yeah, you said bench trial right in there. Gabby, thank you very much. Judge has an orange laptop. I think it's tangerine. I know some people are not happy with me cutting away from the video when it showed Evelyn's body in the state that it was in when they found it. I did my best to show everything that I could without showing the child's body. And I think that I did that in a respectful way, and I think I adequately explained my reasons for doing that. I think you'll find that a lot of other stations that did air those pictures will be editing them out in post, so that, yeah, they might have shown them in the moment, but when you go back and watch, they're gone. I think it's the right thing to do, and I think it just caught a lot of people unaware. So. I make the decision based on a couple things. First of all, I've worked in the news media. I graduated with a degree in this. I've worked in television media. I've shot news on the street for news stations. I know what we can and can't show. I know what the TV can and can't show, what they'll get fined from the FCC from showing. And I don't want to... Yes, it would be like you would get more views. You would get, it's sensational. It would be the shock factor, and I'm not here for that. It's not all about the views for me. Sometimes I believe in doing what's right, and instead of doing what's monetarily more valuable. So I'm not apologizing for that. That also being said, I know there are some comments, I think even on our own Facebook page, that are critical of me of that, and I'm fine with that. I encourage you to share your comments that are critical of me. You're doing it in a respectful way, and I think that topic, if I'm true to what I say, I have to allow that as well, and I do. And so I'm not going to be deleting your comments that judge me for that, or you say I've made the wrong decision for any reason. So feel free to share that with me, and I respect you and your decision. So. Here's some laughter out there in the courtroom. Yes, be here on Christmas. We'll have a Festivus live stream, and you can air your grievances with me then. That's what we did last year. It was a lot of fun. I was talking this over with my wife, and I am worried because things can go wrong, and things are on the fly, and people are doing their best. The cameramen are doing their best. I'm worried in this case, with the judge being as strict as he is, that the media gets thrown out before the case is over. And I hate to even bring that up, knock on wood. But we've seen that before, and it's one of the tools that a judge does have at their discretion, that they can remove the media at any time during a trial if they deem that it's if it's hindering the justice process. And because of that, I'm always a proponent of the media doing what is right initially, and not pushing the limits. Oh my goodness, someone stole $40,000 worth of eggs off a truck in Pennsylvania. Okay, this might be a joke. This might be a joke. But literally, eggs, the price of eggs has gone up so fast, with even Waffle House charging a 50-cent per egg surcharge. I would not be surprised if you could start finding safes with cooling systems built in, so you can keep your eggs in. Chickens are going to be a hot commodity soon. Yeah, we have Festivus. My Festivus poll was actually it's the poll that Mr. Bones resides on. We just take him off, and this is our Festivus poll for grievances. But we'll leave Mr. Bones on there for now. He was on the floor, Teresa. It was worse than that. I threw him on the floor. California, $9 a dozen. Chris, are they free-range eggs at least? Are they, organic free-range? No. Don't change your names. We did have a mass changing of names around Festivus, and everyone changed their name to be a grumpier version of themselves. So everything was grouchy. And a few people still have their grouchy name. You'll see it pop up once in a while. But love it. We're waiting right now we've had a little motion of some sort, an objection to some testimony. The objection was hearsay. I don't know what the testimony was. We think the next witness is the gentleman who was sort of AWOL yesterday, didn't show up for his subpoena, is now on bond. He's still released, free to go, but he has to be in court every day, or at least at court every day, waiting to be called as a witness. The judge looks like he's doing a little bit of research regarding the testimony, or if he's reading it, it's probably going to be some sort of out-of-court statement.
I'm looking at the newest edition of Tennessee Law of Evidence, 7th edition.
He's reading the rule book.
I'm on page 8-60.
We just started after lunch. The judge is handling an objection.
803, 1.2, admission by party opponent. The statement offered against a party that is A, the party's own statement, is not excluded by the hearsay rule. And in the entirety of 806, I'm sorry, of the discussion of Rule 803 1.2, well, in the book, it's section 8.061. But the rule is actually 803 1.2.
I'm going to crank this audio. The judge's mic is either not turned on or he's not talking into it.
There's no discussion of the rule of completeness as applied to the exclusion of a party opponent admission. The only thing it says is that the person against whom the statement is used may testify. And of course, this is a criminal case, so she's not required to.
Judge, did the court refer to Rule 106, Rules of Evidence? I think that discusses the doctrine of completeness in one process of collecting case. The case of State versus Torres from Tennessee.
This is why we had these issues pre-trial. That's why I set so many hearings before court.
I understand. I didn't expect they would dismiss that count of the indictment today, and do this.
Can you tell me, Gene?
One what?
106, Your Honor.
Gene, do you have a document that talks about doing a statement in that case?
I'm sorry?
What happened in this case? Talking about doing a statement.
It's just the statement.
I like a judge that's in control of his courtroom, and this one is. The only thing I don't like about this court is that it's got that air mover fan that is, it sounds like it's an industrial grade engine roaring in the background. Occasionally it shuts off and you suddenly hear peace and silence again. That'll probably be plaguing us throughout this trial. Right now the judge is still deciding an objection to hearsay. And it sounds like it's a statement the defendant made.
1109917.
Which should be a pretty simple one to decide because it's a statement by party opponent against interest. That's a clear exception to hearsay. Jury is not here right now. They're not in. So it's very creepy Kentucky court.
Under a 106 evaluation, what, I guess my question is, I don't know what the rest of the statement says.
Well, that's exactly my point, Judge. There's nothing misleading about what I asked. I didn't ask anything about what Ms. Boswell said. I didn't elicit any testimony whatsoever about a statement that she made. All I asked was whether or not she admitted that she was dead. There's nothing misleading about that, and nothing about what he's going to ask as far as that. All it does is further their theory. It doesn't in any way clear up any misconception or misleading information that I may have presented from that.
According to this Torres case from 2002, in the defendant's murder trial, the court erred in denying the admission of the videotape of defendant's statements. However, the error was harmless because the evidence of defendant's guilt was overwhelming and nothing on the videotape remotely implied that the defendant was innocent of the crime. So, not knowing, I don't know what's on this tape. I haven't seen it. I'm today hearing about it. So that's what I'm asking.
Good.
Okay, so the witness that was on the stand, that investigator, one of the last things he testified to was that there was a point.
That doctor, it doesn't. I don't have to show
where
you
Megan did admit.
Absolutely, it does. I mean, it's right out of the.
Can I finish? I'll listen to you. I mean, no disrespect to anyone here. I'm not trying to upset anyone. But in Torres, there was an issue about that. There are other cases besides Torres. That's the first one I pulled up. There's a State versus Brewer it's the same thing. It's an issue of fundamental fairness. They ask about the statement, then they say, I can't ask about the parts I want to ask about. And if we need to take a minute, I've asked the court for a minute so we can print a couple of those cases and make sure I want to do this right. I know you want to do it right.
Yeah.
Prosecutor Shields.
Okay.
It seems like an obvious decision in
Judge,
favor of
I think there's a good
prosecution.
explanation in the unpublished case of State versus Dylan Brewer. That could be found at 2019 Westlaw 1109917. I forwarded that to your assistant and asked her if she would print it. I have not. And I've given that citation to the state as well.
This jury is sequestered. They will not go home until they reach a verdict or report to the judge they're hung.
Judge, I would go back to the part. The rule requires that a writing or recorded statement or part thereof be introduced by a party. I did not introduce any part of her statement. I asked Detective Fraley if she ultimately admitted that her child was dead. I didn't ask what she said. I didn't ask how she did, if she did it, if she admitted she did it, if she said she didn't do it.
What you asked was if she made that statement to you, in which she get. I mean, I have her go back if that's what you want me to do. I mean,
is this a mistrial motion?
Point the court, the footnotes to the rule of completeness 106 clearly talk. Mr. Scott said it didn't, but it clearly says, rule providing that when a writing or written recorded statement or part thereof is introduced by a party, an adverse party may require the introduction at that time of any other part or any other writing which ought in fairness to be considered contemporaneously with it, provides an adverse party a mechanism for putting portions of the writing into context if the portions would otherwise be misleading. There's nothing misleading about what I asked Agent Fraley. He's not trying to clarify anything.
I see what's happening here. The defense wants to bring in the rest of that interview, which would be a way of introducing Megan's statements into evidence, her voice, her words, her story, without her taking the
Unless
stand.
he's in some way trying to insinuate that the child wasn't dead.
well, we're going to take a minute. I'm going to look at whatever case this is.
Rule of completion is a.
They're having a hard time going through. If we can have a minute,
It's a fun one.
Collect and send them back. I just may need time to do it. Back to your staff.
the rule of completeness where
Your Honor, may I step out for a few minutes?
Yeah, we'll take a few minutes. We're still on break.
We're still on break. Okay, I'm gonna keep them audio on, but we're gonna listen here. Their audio is on, but we're on break. So let me explain this really quickly. What we've had is we have one witness who's taken the stand. He's the detective who did the search and actually found Evelyn's body. And he's testified to pretty much just that search, not a lot outside of that. Although one of the last things he testified was that he was asked the question, was there a point when Megan admitted to you that Evelyn was dead? That's how I understand the question. And he responded, his answer was something to the effect of, yes, there was myself and another detective interviewed her, and that was one of the statements she made, among other things. That's how I remember it, just off the top of my head, how he answered. So now the state has turned the witness over to the defense. It's now the defense's turn to cross-examine this detective, and defense wants to bring in that interview. They want to play the tape. They say, rule of completeness, you got to bring a part in. We need to play the rest so it puts it all in perspective and the jury can understand. This would be great for the defense because there is no way you want Megan to take the stand during this trial. It would be terrible for her to take the stand. Okay, like there's 0% chance she will testify in my book. But here, she could tell her story using this interview and not be cross-examined by the state. So she never has to take the stand. Her story gets out, what she wants to say, which, casting doubt, saying maybe it was this person, maybe it was that person, maybe it happened by accident. I don't know what she's going to say in this interview, but it's probably a lot better than whatever she'd say on the stand if she were sworn in and had to be cross-examined. So this is some spicy courtroom work here. Well, we wait for them to sort out the details. The judge is deep in the rule book, but it seems more obvious. This is an issue that comes up a lot. I think the hearsay exception is out completely. That is a statement by party opponent. That's an easy one to rule on. So it's not hearsay. It would be a self-serving statement that she'd have to take the stand to bring up if defense wants to bring this up. I think it was no. It was the state who objected to what the defense is bringing up. And they said hearsay so it would be hearsay in that case because it is, it's her own statement. It's not a party opponent. So hearsay should be fine to rule it out. Man, this is great. This is great. It's got me thinking. Connor's not back yet. Nope, they've just passed 10 hours according to Law and Crime. I've got 10 and a half hours on my clock. We may have run the time up a little bit. Still hearsay, just permitted, right? Hearsay is any out of court statement, basically. So if it happened outside of court and someone's reporting on it or playing it back or reading the statement that was written, it's hearsay. Whether or not it's permitted, that's the issue. Did you see her interviews with the news before baby was found? There's a few of them. I think we're going to see them. And the reason is we have, 10 plus charges about filing or making false statements. I'm confused and RA is not helping. Collin. Did I say Connor? Collin Griffith is who's on trial in Florida. Jury's still deliberating. No verdict yet. We're going to be talking about Collin Griffith and that trial on Courtroom Confidential channel this evening, about 8 to 8:30. So I believe that will be live. So I'd love it if you guys could join us. I really like Josh. He's amazing. I've got to sit down with him twice to do an interview. Together between those two interviews, there will be one final product because of a tech issue. But I enjoyed both times. I'm really looking forward to it. He's got a great channel. The production value is phenomenal. He's a great he's an attorney. I believe he's a criminal defense attorney out of Los Angeles, California. I haven't asked him yet, but I've heard that he has worked with Alan Jackson or has worked at least close to him. Do you wear the same shirt size? I wear the same shirt size I did when I started live streaming. Does that count? Glad when juries take their time and take it seriously. Thank you, Amber, for the link. Courtroom Confidential is amazing. Great channel, great insight. I love the different programs they do. I love the interviews they do with different channels, a little behind the scenes. I've been on a few different creators' channels as a guest, and it's an honor. I can say that. It's an honor to be invited anywhere. Their interview was different than any others. It was more sort of about me and what inspired me to do what we do here. What happened in Thurston County? Mark, we just had the verdict at the start of this stream. If you want to go back right now and watch it, you can. Otherwise, if you stay here, we'll probably spoil it for you accidentally. Larly Annie, thank you so much. Appreciate your continued support. And reminding people to click the like button if they like it. Larly has been giving membership gifts as soon as we hit the 1,000 likes count on the stream. So thank you, Larly. You're very generous. Appreciate it. Okay, so he was the DA's office, not defense. He worked with Alan Jackson. And was a partner. Then he was in Alan Jackson's defense firm. Now at a different firm. Okay. He is great. I can tell you that. Just a great individual. I cannot wait to have more opportunity, even possibly to bring him on our channel one day if he's got some free time, because he works a real job during the day and does this as well. So, does the court reporter have a can of Pam on her desk? I think it's WD-40. Let me look at this. It's in big in the pixels for me. It does look like some sort of aerosol spray. It's not Southern Febreze. I can recognize Raid anywhere. Now I'm curious. I might have to Google the image. A red lid. It does taper at the top, which would, it's not spray paint. What aerosol would a court clerk use, or the court recorder? Just compressed air. An air duster. That's a great idea. Strawberry milk. It might be that as well. She's greasing the wheels of justice. We're going to get that verdict one way or another, right? I think the most Occam's razor, right? Most logical conclusion. Spray dust off the keyboard is probably it. Future says if I would look at you. I was looking at the screen. I actually have to move my system around. I've got to move this closer to here, and this microphone here is going to go over there. I just have to unplug a few cables to make it happen. So one day we'll do that. Yes, on the canned air, you can confirm. So Sinbad, I have the same one. Ozzy, good to have you here. Welcome. Thanks for the support. Bear spray in case things get out of control. Yeah, wrong answers only. Sorry, I didn't realize I was stuck on that screen. I was looking at chat and not paying attention. Wrong answers only. What does she have on her desk? It's Tennessee. It's probably hairspray. Could be. I like the bear spray idea as well. Especially after watching that fight in New Mexico, the courtroom yesterday. Whoa. Y'all should carry there in the courtroom. Silly string. Yes, for the not guilty verdict. For the funny case when they have the not guilty verdict, spray the silly string. What was the first trial you watched? The first one? Probably Johnny Depp. I mean, I don't know. I watched what's the gruesome murder, stabbing the boyfriend, stabbed the boyfriend, took the pictures. Jodi Arias? Watched that one. That was wild. It's an air horn. I didn't watch Rittenhouse. The first time I was actually, I saw parts of that, but the first time we saw that judge was with Judge Schroeder, Zachary Anderson. Thank you, Mathis. Zachary Anderson. That was when we were first played in court. Like our live stream was played live in court for everyone to hear. That was crazy. OJ Trail got me hooked. I think I was in high school when that happened. Like I was a senior in high school, and so I followed the news. And the slow speed chase is what I remember. I don't remember any of the trial other than the headlines and the glove doesn't fit. You must have quit. I didn't see much of that trial. First trial you streamed with us, that would be Daryl Brooks. Spray cheese. It's spray cheese. You got a box of crackers up there too, maybe. I don't consent to that now. I've got the sound effects turned down. I'll turn them off altogether when court begins, but we do have a few sound effects for those that are new here. Like that one there, that can be triggered by you guys in chat. There are various commands we use. We try not to interrupt the court because we're all here to hear. The apocalypse may be upon us. We're all here to listen and learn and watch, and so we'll turn them off when important things are happening.
Stuff that is not relevant.
But now everyone's triggering all the commands.
I'm not a camel.
Hey, Law Talk with Mike is great.
Somebody just sent me a video of roaches fighting. I don't know who won.
Thank you, sir. You're my new best friend.
You guys are playing all the sounds.
Because he's the guy.
These sound effects come from courts that we've watched for the most part.
I think I'm about to catch a whooping.
That was a good one.
I'm not a cat.
Squirrel.
I'm not a cat was a
Shame
meme.
on him, sir.
I was kicked back, taking it easy.
That was an arraignment.
Happy
out of
birthday.
Nashville.
You look good.
That's Judge Fleischer.
In front of the Walmart.
That's every trial. That's also out of Nashville.
Alex stole it.
That was Alec Murdaugh. Oh, Mark Jensen.
The zombie apocalypse may be upon us.
I'm not a camel.
The roaches sound came from what court? That came from Judge Stephanie Boyd in San Antonio, Texas. She's trying to scare people straight.
Somebody just sent me a video of roaches fighting. I don't know who won. She
was talking about the jail and how it's just a dirty, creepy, crawly place and you don't want to go there. And she's like, someone just sent me a video from the jail of roaches fighting. It was funny. The judge is on a little break. He has allowed the cameras to stay live, but the audio has to be off during the breaks. And so we sort of get a peek into what's happening or what's not happening, but we can't hear anything during this time. I still want to know who won. Letitia was the last trial we did.
Are we going to address subject matter jurisdiction?
With a young.
Thank you, sir. You're my new best friend.
A young victim like this one, and it's that gives you an idea.
If they didn't, I
how
would
rare
lose
it is.
my mind.
How rare it is for us to cover cases
This is
like
not
this.
Burger King. People do not get to have it their way.
Stephanie, member for 11 months. Best 11 months. Super memories.
Miss the forest for the trees.
Super memories made already. Looking forward to making more. Thank you, Stephanie. Appreciate your support. It wouldn't be the same without you here. Harmony Montgomery was after Letitia. We did not cover the main Harmony Montgomery trial. We covered the firearms trial. So it was connected to it, and there were some facts that came out. But the actual one we did.
I saw a chicken fight.
Allegedly, Amy, congratulations on your second month. You got a new color of courthouse. That will change again next month for you. Thank you very much. Ohio Jen, I've been here since Daryl Brooks' grounds. Ohio Jen, we can see that from the pink courthouse by your name. It looks great.
Because he's the guy.
Thank you very much.
I think I'm about to catch a whooping.
I can't remember what the whooping was.
Are we going to address subject matter jurisdiction?
That was the judge. That was the defense attorney who was trying to get his assistant to sit at the bar with him. The judge wouldn't let him.
I was kicked back, taking it easy.
What case was that?
How does he do that?
What's the whooping case? I think it was in Florida. Was that Benefield? That was actually Benefield. Adam, thank you. You guys are right. Amanda, thank you for the whooping. Was in Ashley's greetings. You guys have great memories. I appreciate that. AJ Red Sox member for 4 months, says best channel for court cases. Thank you, AJ Red Sox. Congratulations. I wonder what team you cheer for.
What more do you need to see?
What baseball team would be your favorite? All right, I'm going to turn him down here because I think you've played them all. You've played them all. Greener says my memory is only for this stuff. We're still on verdict watch. Yes, 10 hours and 45 minutes by my count in Florida. What's going on right now? Lisa, there has been an objection, and judging based on whose turn it is to ask questions of the witness who's sitting up there in the witness box. He was the first witness of this trial. I believe that the objection came from the state, and the objection was initially we heard hearsay is when it first opened up. The defense wants to play the audio recording of the interview of their client, the defendant, Megan, with this witness. And they're bringing this in saying under rule of completeness, this witness testified that the client said in the interview that she at one point admitted that Evelyn was dead. Was no longer alive. And so they're saying under rule of completeness, we should be able to bring in the rest of that testimony, even though we didn't hear it. We should bring in the rest of it, and this would be a huge win for defense because they get to present the story that Megan told law enforcement, or at least a version of the story that she told law enforcement, in her own words to the jury, without Megan being cross-examined by the state. And this is the very reason why I think hearsay is not allowed. I don't think it's fair for them to be able to do that. I don't think the state crossed the line and they didn't play a portion of that. It's not out of context. It doesn't make the statement confusing or construe the facts differently than how they were portrayed during the interview. But the judge is ruling on this. There's been some case law brought up both ways, back and forth, and now he's gone back in his chambers to make a decision. And we'll see what happens. Are we counting objections? We are. We're up to 3. This was the 3rd objection. So we've had 2 objections by the defense and 1 by the state, although we're not differentiating between the 2. Cameraman's just finding out where all the buttons are. It's working. It's doing great. This court does seem to have bailiffs just scattered throughout the courtroom in weird places. The defendant gets a break. Making sure we can see their screens. We can. And what we know so far is that the defense has been watching Court TV, the live stream, on their, not on the main monitor that we see right above my head right here, but on this one right here. They've had Court TV playing on that, so they are mindful of the TV stream that's going out. I haven't been watching as much on the state side. We do know from previous trials that oftentimes attorneys or some of the people from their office will watch our live feed. That's one of the reasons why we ask people to be respectful, because you never know when we might have family members of a victim, family members of a witness, or family members of one of the players, the officers of the court here, or defendant here with us. Everyone's getting breaks. I guess it's taking longer than we expected. We found out in the Melody Ferris trial, that firsthand, when Martha Jane, someone who was on the potential witness list but had not been admonished not to watch court, was watching our live stream, heard something that I had said when I tried to draw a conclusion based on evidence, based on how I saw it was going, and turns to to prick her conscience, and because of what I said, she called me the little man in the corner. She called up the detective and said, I have to tell you something. My gun's gone missing. My .38 Special's gone missing. And the defendant was the only person who knew where it was. And when I watched the little man in the corner and he said, that's where she got the gun, I knew I had to tell you. And I didn't tell you before because you never asked. I knew it was missing, but you never asked. And so that ended up with us getting admitted, like a screenshot of our live stream with me with a goofy face, like halfway, like it's crazy. Screenshotted. That's the moment the attorney chose to screenshot it and submit it into evidence into court. So we're in that court case file as well. DNB said, Sweet 16 already. Can you share the link to RA's Friends map? I can't find it. Amber, do you have that readily available? We have a map where it's a Google form, and there are 2 questions. There are 2 links. The first link is where you put your YouTube name and your general area. We don't want your complete address. You don't want to dox anybody, but your YouTube name and your general area. If you're in Houston and you just put Houston, there's probably going to be somebody else who's already got their pin on the map there, so you might have to be somewhere a little more specific. So if you're in a big city, it might not show up as easily. But wherever you put on the map, it will put a pin for you on the map, and you can see where everyone else is as well. And you can see we've got people in every state, pretty much across the world. Russia's a bit underrepresented, and China as well, but we've got most of the European countries as well. So make sure you follow the instructions on this pin. The first one, and thank you, Samantha, for linking this. The first one is the form where you submit, and the second one is the link where you can see all the answers. And we do manually check these to make sure somebody doesn't enter a name that's highly offensive or that clearly a prank, and we filter those out. So it takes a little bit for it to show up. It won't be instant. I didn't see the Ashley Benefield interview with the prisoners in New York State facility. I didn't see that. I think it was Dateline that did the special on the Melody Ferris trial, and they did cut that portion out of the retelling. They never mentioned our channel, which is fine. I'm not, I don't know how they would tell that. It throws a kink in the story that's hard to work into a 60-minute program. It's still the same chart. It's just for new people, Virginia. If you've already done it, it's good. Yeah, please only do city, state, and country, or else Amber has to choose another place in the world to have you be from. Okay, standing's been fun. I'm taking the seat again. Let's see. David, in Scotland, we have 3 verdicts: guilty, not guilty, and not proven. We've actually done that a couple times. We have a couple people who've suggested when we do surveys towards the end of the trial, after all the evidence is in, to use the Scottish method. And I like that because a lot of times I'll feel that it's more than likely the defendant did the crime he or she is accused of, but I don't think the state's proven it. And our current system doesn't really allow you to express that. A Pink Swan just gifted 5 memberships. Thank you, Pink Swan. Like the little pup in your profile pic as well. Not proven has been abolished. You went to Scotland, got away from it? Now it's just guilty, not guilty? The Scottish system is a mess. It's our roots. You can't look at our legal system and completely separate it from the roots that we came from. Steph says, can I have a quick summary of what I missed from this morning? Steph, I think a quick summary is the best way to handle the evidence every time we talk about what we missed this morning. But we've had one witness in this case. The trial began with a reading of the indictment, and there are like 20 charges. Most of the charges against Megan Boswell are that she lied to investigators or made false statements that hindered the police progress in finding Evelyn. So that's most of the statements. We heard the entire thing read, each charge, one by one. She is accused of killing her child, Evelyn, and disposing of her body in a garbage bag, like a kitchen garbage. Not just a kitchen garbage bag, but literally the kitchen garbage with eggshells and candy wrappers and everything else, and leaving the body for months in her childhood playhouse in her parents' on her parents' property, where the child was eventually found. Now, the state has suggested, or defense has suggested, that it wasn't there initially, and it might have been moved during the process, because a cadaver dog went through at one time searching for the body and didn't hit on the playhouse in that yard, and then when they came back, obviously they found it. But this morning, the evidence has mostly been about that search, about exactly what it was like, what the yard was like, what the playhouse was like, the shed. We've seen the map of the yard, and then we've seen a lot, probably 40, 45 plus pictures of the actual scene where Evelyn's body was recovered, and how it was wrapped. How it was wrapped in. She was wearing a purple onesie. She had a blanket outside that. How the body had been tightly wrapped in the blanket, and tinfoil had been wrapped over the child's head, and not just wrapped, but shaped to Evelyn's head, which is, worse. But very, very difficult testimony to listen to. But those are the facts of the case, and they have to be laid out to the jury, and they've done that. Let's see. It's not good for defense, but also it's the only thing they've really proven so far. If we look at the elements of the charges, are possibly some of the elements that have to do with failure to report a death or desecration of a corpse, abuse of a corpse. They still have not proven the premeditated murder, and I think that's what the majority of the trials can be focused on. The bigger charge. Very similar to Casey Anthony's case. Lizzie says, can we view other people's names on the map to see who's close to us? You have to go up to the left-hand corner, and I think there's a search field where you can type in someone's name, and then it will show you where they are. But you can't just, see all the names on there. It's a little bit clunky. It's more of a visual to show where people are instead of who's there, but you can get to it if you want. Rachel, this is my goal. This is my goal in this case. I love that Tennessee's taken a step to punish people that do this, to make people want to report things sooner. But I think we as community members need to be more alert, more aware, and more willing to not just turn our head away like we saw in the Collin Griffith trial, where the neighbor saw the I would say the fight that was going on outside her house, and just like, hey, don't look, out of sight, out of mind. I'm just going to go step inside like it didn't happen. I don't think we can do that, especially when kids are involved. Let's see. Casey Anthony was a surprise. That one blew me away, how the jury got there. And I wasn't watching that case like like I've watched other, like we've watched other trials. So I didn't see all the evidence. I don't know exactly what the jury was able to consider and what they weren't able to consider. But that floored me. We're waiting on the judge to make a decision on whether or not the defense gets to play the audio or video recording of the interview of Megan Boswell, where she admits that Evelyn is no longer alive. That's what the fight's over right now. The judge has been given some case law. He's heard arguments from both sides, spicy argument even, and he's now off making a decision. Is he phoning a friend? He might. I don't think a judge legally can allow someone else to make a decision in a court case, but I'm sure that they have their own little Facebook group where they can say, "Hey, have you ever had a case that has this sort of thing? What case law did you rely on to make a decision in XYZ situation?" Susie says, gave up on not catching gifts, so treated myself here, then caught a gift on another channel yesterday. It's weird. Susie, what we've seen is that YouTube went many months without. I mean, there were people who would get gifts on the channel fairly regularly, and then YouTube sort of shifted, and they didn't get any gifts. A lot of those people didn't get any. We're slowly seeing those people start to appear again in the gifted memberships. So we're hoping that YouTube lets everyone back in again. Candace, I get gifts to weird channels I don't think I've ever watched or haven't watched in a long time. Got 2 gifts on channels yesterday. One I'm mod on. That's always fun. My wife is a mod on this channel. She's received gifts as well. That's my house alarm. Sorry about the beeps. In my opinion, you might have to refresh. I think it was working. Let's see. Unless Amber's telling me it's not. Let's see. Amber's busy. Amber's busy putting greeners in Gitmo. Sorry, I'm outing you there, Amber. If you look at the map, we have a viewer in Gitmo now who may or may not be greeners. How long do you expect this trial to last? It's supposed to be 2 to 4 weeks, but the way we're going today, I would lean heavy on the 4-week side. This is a long decision. I would have thought it would have been quicker as well. Let's see. Did you see the flash go off this morning? Kitty Kitty Bang Bang. I didn't see the flash. I watched chat a little bit. I could probably rewind and see if I could catch the frame where it happened. But it sounds like it might have been a phone she was using, which is weird. Because she said something about, I turned it off in the settings or something. I don't know. It could have been a digital SLR. Usually you want a digital SLR for courtroom photos. It's been so long I've forgotten what they're arguing about. Maybe the judge did as well. I'm showing about 11 hours of deliberation time now in Florida with our case down there. Let's see, box 3 will be 3. looks like that right there down in Florida. Law and Crime has a more conservative verdict clock. You guys want to see the map? Can you post it again in chat, Ember? Oh, Sleepy Vapor. I get the reference. That's the Kentucky trial, which I'm super interested to follow as well. Amber. Amber and Greeners. I might need to time you both out. Greeners, that's only for 60 seconds. There's the link. Just 1 second. Give me a second. We'll get this full screen, and I'll show you the map of everybody. All right, while we're waiting, here's the map of viewers. Starting at the United States, as you can see, we've got some pretty good coverage with every state being represented. We've got South America on the map as well. Mods in multiple countries. Well, that got crazy really quick. Not a lot in South America, but look at that. We've got a few down here. Uruguay, Buenos Aires. That's awesome. Australia is on the map. New Zealand. A lot over here in Europe. Got Iceland as well. Norway, Sweden, Denmark. UK representing well. Scotland, Wales, Ireland. We've got several in Germany. France, Switzerland. You're testing my my geography skills. I can't read these. Let's see, Vienna, Bulgaria, Lithuania, Portugal, Spain, Greece. What's this one? Is this Nigeria? Nigeria is on the map. Welcome. South Africa as well. Welcome to y'all. Here we go. We've got a lot of people. Hawaii, Alaska, Canada as well. Very well represented as well. Canada, the majority of, I think 7% of Canada is holds about 90% of the population, or maybe more. That's right there across the border. So well represented there, except for the northern provinces, which is not represented by anybody most of the time because it's freezing up there. So appreciate y'all putting your pin on there. Do you still eat those pickles? I still eat pickles. I had pickles for lunch, actually, before I had my my chicken and fish sticks. I had some pickle snacks. I did not have spicy maple bourbon pickles. I don't have any right now, so I'll have to go and get them. Greeners and Gitmo is on a hunger strike. I see you changed your name. You know, when you keep changing your name, it's going to get stuck like that, Greeners. Let's see. Kathy, we did not get the body cam video. I believe their answer was that they delete everything as soon as it was done, and we were right after, and they zoinked it. It was gone. Tracy Lynn volunteers to move to the True North, bold and free. to represent the Northern Canada territories. Canada does represent. We appreciate all our Canadian friends who join us here. We have quite a few. My picture changed too. You put bars. Grady has put bars over his profile picture. Oh, man. That's awesome. Sugar Baby, welcome. Shout out to Nigeria. Do you still collect coins? I do. I collect... I collect what's called challenge coins. This happens to be a spinner coin where the middle... I'm going to turn it on autofocus so you guys will be able to see. This is a Wright Brothers coin, and the middle spins. So on one side it has the Wright Brothers picture. On the other side it's got their plane. Nice little double-sided coin. Got that one. Here's one I got from a sheriff's department for doing some filming work with them. That's actually a 9/11 memorial coin. It's pretty cool. It's got some green on it, so it gets keyed out by my keyer. Here's a little unique one. It's an 1.5-inch coin for an event that I was a videographer for metal detecting. It's one of the biggest metal detecting conventions, and it's held in my state. It's a lot of fun. So I do collect those. I just sent a bunch of them up to... I think I sent this one as well. This is a Civil War coin commemorating the battle at Gettysburg. Just sent a bunch of these up to Ian in Canada. I'd promised him some. So, little cannon on that one. It's got the two flags on the back. Let's see. Judge is back. Judge is back. We don't have a witness, so let's make that happen. Let's see if we can get some audio here in just a second. I've thought about making coins for the channel. The jury's not there, as we can see. Also, the defendant is waiting to come in. This is our first shot we really get of the defendant's face in this trial. She's always been facing away from us. She's going to be brought in just a second. I thought about making some coins for the channel. The difficulty is I'm not a graphic artist, and I want them to be high quality and something that's worth the cost that would be involved, because they're probably going to run about $25 or so, just because the dies are expensive. I'd like it to be a 2-inch, a nice challenge coin that people would be, it would feel good about put it on their desk on a display or something like that. So I just need some artwork that can be rendered in 3D, so it's a relief coin, and then it's just going to cost a couple $1,000s to pay for them to have them get made. So there she is. Ooh. A very different look than how I pictured her. First of all, I didn't realize her hair was that long. And wearing the green, which sometimes is associated with mental illness awareness. I'm not sure if that's intentional. I should do an art contest. Sobriety coins. That's basically the idea. It's a very similar idea to that. But I'm sure we have some graphic artists. I just can't afford it right now. It's it costs thousands of dollars to have a die made, and I'm just not confident in my artwork to spend that much to get one made. Here we go. Yes, she is in custody on $1 million bond. She's held on $1 million bond.
All right, Mr. Scott, you handed me 4, 3, 4 cases.
4, I think. Be ready here. Judge, I handed you the unpublished case of State versus Brewer, and that case contains a pretty good explanation that it does cite to several published cases. If you go to, if the version you have of Brewer has a page 12 at the bottom, does it?
Yep.
If you go down to the last paragraph of page 12, it talks about 106 is a rule of timing and admissibility, and talks about whether it's not immediately clear where it would admit the introduction of otherwise admissible hearsay. That paragraph goes on to state, though, however, it has long been the law in the state when a part of a confession or admission is entered into evidence, the defendant is entitled to have the jury consider the entire confession. That cites Curry versus State, 397 Southwest 2nd, 179 at 181. That's Tennessee Supreme Court, 1965. And Samblin v. State, 387 Southwest 2nd, 817 at page 820. And that's, again, Tennessee Supreme Court, 1965. And they go on in this case, they talk about when a confession is admissible, the whole of what the accused said upon the subject at the time of making the confession is admissible and should be taken together. If the prosecution failed to prove the whole statement, the accused is entitled to put into evidence all that was said to him or by him at the time which bears upon the subject of controversy, including exculpatory or self-serving declarations connected herewith. It is for the jury to say what weight shall be given to several parts of that statement. For they may well believe the part that which charges the prisoner and reject that which tends to exculpate him. And that's a direct quote from State versus Robinson, 622 Southwest 2nd, 62 at page 71, Tennessee Supreme Court, 1980. And in this case, in Brewer, the Court of Criminal Appeals goes on. This case is kind of almost on all fours the way I see it. The Rule 106 here in Brewer, the state examined on direct examination a witness about a statement. It did not put in a play that put the physical statement in, nor did the officer read the statement verbatim. But they said the rule of fairness should allow you to place the whole statement in. And I think, Mr. Fraley was asked in this case, he was asked about taking a statement. I think he was asked a couple of times about taking a statement. And he was asked about her admitting that the child was dead. Well, certainly in a missing persons case, when you admit to the police that it's been shown and alleged that you're lying to, and Mr. Fraley, although the court granted an objection, said earlier that she was telling lies, and then when she fesses up and says the baby is dead, certainly the court should take that as a confession. And I think he was asked about the baby being dead, and the response was that the baby was dead among other things. So that leaves that out there for the jury to be wondering what the other things are. That's my recollection. That's Mr. Horn's notes. Now, that's essentially my argument. I'll rely on the other cases I gave you, but I think that Brewer case gives the best explanation. Although it's an unpublished case, the cases it cites to certainly are published. And if you have any questions, I'll be glad to answer those. If not, I'll yield to Mr. Harper.
Yeah.
Judge, I would agree with Mr. Scott. I think the Brewer case is on point. I would disagree with him as to how he's reading it, however. One, I don't think anything about what I elicited was in any way a confession by Miss Boswell. And two, I would rewind a little bit from where Mr. Scott quoted on page 12 of the opinion, because the danger that we're trying to avoid here is misleading the jury by providing only inculpatory parts or parts that somehow make the defendant put the defendant in a bad light, and not putting forth the parts that are inculpatory or in some way would mislead the jury about the proof. And in the paragraph above where Mr. Scott quoted the rule of completeness that was explained by the Supreme Court, it talks about that the rule must do one of the following, and then it lists 4 things. 1, explain already admitted proof. 2, place admitted proof in context. 3, avoid misleading the trier of fact. Or 4, ensure a fair and impartial understanding of the already admitted proof. Well, what he's trying to elicit doesn't do any of that stuff.
See, that's my problem. My problem is I don't know what he's trying to do.
Well,
I've not been told yet.
All right, I guess I'll go ahead. I believe he's trying to elicit that what Miss Boswell told Agent Fraley was that her...
Fraley step out.
The witness is being asked to leave.
Mr. Scott can correct me if I'm wrong, but I believe what he's trying to elicit is that Miss Boswell told Agent Fraley that Hunter Wood, the defendant's boyfriend, rolled over and killed the child. And that was what she told Agent Fraley at that time. I don't know how that corrects in any way his statement that she admitted the child was dead. I mean, if anything, that's the fact she was there is more inculpatory to elicit that than it is correcting any sort of misleading impression that might be out there as a result of what Agent Fraley's already testified to.
The judge is frustrated that this is brought up now and not pre-trial. It's like we had a lot of weeks to sort this issue out. And here we've got a jury sequestered, and now this comes up.
Are you satisfied that that's an accurate summary of what the proof is, or do I need to hear the whole 2 hour?
I would.
Because there's, in this case of the case, I don't recall which one it is, but I read that one of the arguments was that the defendant on possibly the post-conviction case, there was argument that because the judge relied on the summary of the proof instead of reviewing the entirety of it, that the judge couldn't make that decision.
I think, and Mr. Harper can correct me if I'm wrong, I think I'm generally satisfied with what he's saying, but she explained how the baby died, where the baby, or maybe not where the baby went, but I think that Hunter took it in that statement. Am I right about that? Yeah. She gives an explanation, and I guess what I'm trying to say right now is it's fundamentally unfair, and I think it does satisfy at least 1 or 2 of those things that Mr. Harper's talking about in the paragraph above from Brewer. Explains the already admitted proof and puts it in context. Well, right now you have a case where the jury's heard this TBI agent say, yeah, she's lied and she's basically led us on the wild goose chases, but she finally admits the baby's dead without putting in the full explanation of what she told them. And I think for the jury to hear that, there's no mention of anyone else and what was put in. She tries to explain to him what happens, and I think it explains it, and it avoids misleading the trier of fact from the standpoint of the jury. You don't know what this proof is. Mr. Harper and me, Mr. Harper, Ms. Maskill, we know it, and I think you said that's where you're struggling. Well, you have.
Obviously, it's where I'm struggling because the test that the Tennessee Supreme Court has given to the trial judge is that it is an issue of fundamental fairness. It isn't an issue of one snippet of one statement misleads the jury. That's not the test. That's not the question. The question is it fundamentally unfair if I, as the trial court, don't allow you to put in the entirety of the statement based on the very narrow, and I understand General Harper was being very careful and cautious in what he was asking. So what I think where we're at is that I'm going to have to, is it transcribed? Is it audio? Is it video?
Video. It's 2 hours.
Judge is going to have to watch the whole 2-hour video.
I think I've got a clip of just that portion.
Well, here's the other thing. If you want to give me just a clip, obviously it speeds it up today, but then if the jury ultimately convicts, then on post-conviction or during the appeal, the argument's going to be, oh, well, the judge didn't review the entirety of the statement. And therefore, he couldn't have made an appropriate determination. Here's where we're at. It's my opinion, and believe me, there's nobody in this courtroom who wants to keep this case moving. But it's my opinion that you're going to have to give me the audio or video or whatever it is, and I'm going to have to go back to chambers, and I'm going to have to review it. And then I can come out here and make
That's a 2-hour delay.
a decision based on this law. I think that's where we're at. I don't want to send the jury away, but I'm not going to make them sit out here for 2 hours.
I think maybe you're going to have to. I mean, if I'd have known this was going to come up, if they'd have known, we'd have brought this up. But I don't
I'm not
think.
mad at anybody.
But I do think the court needs to consider when you do this, is this a confession? Because those state Supreme Court cases that are cited in Brewer go back to 1965, and I don't think
I'm going to tell you what I'm going to do. And the last case that you gave me gives me this freedom. I'm not going to go back to 1965. I'm going to rely on the rules of evidence as they've been enacted in this state now for some time, and the cases that talk about the rules of evidence. 1965 predates our rules of evidence.
I understand that.
And even our Supreme Court in one of these cases says, look, the defendant in that case made arguments relying on the old cases. And the Supreme Court says, look, we're going to look at this under what the rules of evidence say. And that's where that's my story.
Okay. I want you to understand my position is this. I think the defendant under due process protections given to her by both the Tennessee Constitution, the federal Constitution, has a right to fundamental fairness. And I think those cases, that's what they're talking about, is fundamental fairness. So
I think I just said that.
I'm not sure that there's a difference between if there's the rules of evidence provide for fundamental fairness. I understand what you're saying. Let's make an example. And if I'm wrong, I think we're on the same page at least.
This is a smart move by defense. I don't know the intricacies of Tennessee law that make this such a tough decision for the judge. But the defense, this would be a huge win. You basically get your clients to testify without being cross-examined.
Yes, sir.
It's massive.
Where we're at right now, I'm going to have to bring the jury in. I'm going to send them, since this is day one and they've not been to the hotel yet, I'm going to go ahead and just send them to the hotel. So I'm going to have to, is it listen to or watch?
It's video.
It's video.
All right. And I may have the whole issue about whether I can see and hear what's being said. I've had another case where I had Sullivan County videos that I could not
pretty clear.
These are pretty clear, Judge. There shouldn't be any problems.
So I need to bring the jury in. Lieutenant, so you know, I'm going to go ahead and send them to the hotel.
Yes, sir.
Let them get settled in.
The jury is going home for the day. That's what we know.
Your Honor, I think did we not get in that other case, those
I
statements
still
with the
got it.
Bluetooth?
I still got it.
Did it work that way? Okay.
Well, the jury's coming in. I've got to tell you, in my little hometown, quirky as it is, there are a couple stores that I love. One is called Quilt Lizzie, which is all about sewing and quilting. I'm not a big sewer or quilter, but I have done some tech work for Susan, the owner there. And the other is Coltrane Hardware. And Quilt Lizzie on her YouTube channel just did a tour of Coltrane Hardware. And what's funny is at the very beginning, she messes up. She's like, "Oh, she finishes that word. They haven't cut it off yet. I want everyone to watch it before it goes away." So I'll send you a link in chat. It's funny.
You may be seated. Thank you.
All right, ladies and gentlemen, I hope you enjoyed the lunch first. Second, we've got a legal issue that's come up that I have to do a little bit of research so I can come to the right conclusion. And it's going to slow us down a little bit. But since this is the first day of sequestration, I'm going to go ahead and have the officers take you to the hotel so you can get settled in. Your luggage should already be there. I think they've already told you all that. Then they'll take you out to dinner tonight to some undisclosed restaurant somewhere in the Tri-Cities. But before you go, I'm required by law to give you certain admonitions. 1, you're not to communicate with other jurors or anyone else regarding any subject connected with this trial. You're not to form or express any opinion about the case until it is finally submitted to the jury. You're to report promptly to this court any incident involving an attempt by any person to improperly influence any member of the jury. You're also to report promptly to the court a juror's violation of any of these admonitions. You're not to read, watch, or listen to any news reports concerning this case. You're to decide this case solely on the evidence introduced in this trial. Okay? Now, we'll start back at 9 o'clock in the morning, and I will see you then.
One stand, please.
Judge, you're up in his Mac computer. I was not quick enough. They took the video down. She says, "Oh, she messed up at the beginning." She swears, and she's a funny lady. And in the video that she just took down, and the lady who was filming said, "So it's okay, I can cut that off." But they posted it with it on. I was hoping you get to see it before then. Okay, so what's happening here is actually a big deal. Not so much with the jury. The jury's sequestered. They're going to the hotel. Everything's fine with them. This is. I don't think we're in mistrial area at all.
All right. Y'all, we'll be in recess till 8:30 in the morning. I need y'all to get that statement to me and changed.
So, Judge, may we approach? Talk about something else.
This is bad. I'm not the legal scholar on Tennessee law that I'd like to be in this situation, but it does seem like the state had weak arguments to defend against the defense's. I call it an attack, right? This is a chess move. This is a chess attack in court. Their arguments seemed weak. Just throwing hearsay up, where I think there was a bigger issue. And they could have brought up and talked about the issue of a defendant being able to testify and getting statements from the defendant in court without cross-examination, and how the laws are structured to prevent this very thing from happening. But they didn't do it, and now the judge is going to be watching 2 hours of the interrogation video in his chambers, and we're done for the day for this court, and trying to decide if the letter of the law of fairness applies to this other part of the rest of the 2 hours when the officer, all he mentioned was there was a time, among other things, that she said that the baby was dead. Are we sequestered too? Yes, you are, specifically. But this case has already got some legal questions that are heavy enough that the judge is worried about appeal if he makes the wrong decision here, because this is a fairness issue for the defense. So he wants to make the right decision. Is the interrogation video available online? I have not watched it. I try not to watch the evidence that's available online that might not come into the jury. I like to look at the case as the jury sees it. It helps a little bit. Michelle Phillips, welcome from my own state. Still no word on Collin's verdict. I can tell you there is no verdict right now. They're plus 11 hours. I'm showing 11 and a half on my clock. Still deliberating. No verdict in that case. What's happening in Thurston? Eeyore, we had the verdict in Thurston. If you missed it, it was right at the very beginning of this live stream. And it has a telling little soundbite in there that you need to listen for about the new clerk. That's all I'll say. Listen for that. Do you feel like this is make or break for the case? Carter, I don't think this makes or breaks the verdict, but this is a massive win for the defense. How else are you going to get the defendant's story in the version she wants to present? There's a lot of things she told to the media, and that will come in. We're going to hear all the different stories they told, and but this is her own words. It's her telling the story in answer to questions similar to questions she might be asked on the stand, but she's not able to be cross-examined in this one. And I think this is if they get this, it's a huge win, massive win for defense. Talking to cops just never goes well. Kelly, so her defense, it wasn't me. I missed defense opening. Defense said it could have been a couple things. It could have been an accident. They say it could have been SIDS, which is sudden infant death syndrome. Even though the baby is sort of on the outer limits of the age where that is typically occurs at 13 months old. They say it could have been somebody accidentally rolled over in bed with having the baby sleeping with them, and the baby was asphyxiated that way accidentally. But they're admitting that what you did was pretty bad with not telling anyone and then hiding the body. But they admit that in their statement to the jury. They have not pled guilty to that in the charges, because they say the wording of the charges is such that it makes it look like something it isn't. And so she's pled not guilty to all the charges that are raised against her. I am seeing somebody just walked across the court in Collin's court. The timer is still going. We're not seeing any updates yet about a verdict. I'll let you know if there is one. Let's see. Are you saying verdict in Florida? The verdict clock has stopped. It stopped. Like right now, like it's showing 5. It's showing 5s. What is going on in Florida? Let's take a quick gander around there. Let's see. We might get the music twice in one day. We're looking for a confirmation. There it is. Collin Griffith was charged with felony murder, first-degree murder, kidnapping in this case, of his own mother. This is a case that shocked the nation when it broke the headlines. Sheriff Grady himself did a press conference on this, showing the picture of the knife, the picture of Collin, and it reverberated around the nation as we heard the allegations that Collin had taken a 12-inch kitchen knife and plunged it through his mother's neck. The evidence in this case was shocking in a couple areas. First of all, Collin has done something of a similar nature before. And you say, what? How can that be? His own father passed away when Collin shot him once in the chest and once in the head. That case initially in Oklahoma was ruled a self-defense, or I will say it was determined not to be prosecuted because they could not rule out self-defense. And so just 19 months later, his mother is dead in her mother's kitchen, and Collin is the only person in the house other than her. So this case, Collin did not testify, but we have heard a lot of testimony from other people who knew Collin and said that he was foreshadowing this action, even telling them that if his mom ever did something to him, and there was some back and forth there, that he might do something to her, including this very thing. So Collin, who was convicted of domestic assault against his mom previously, is now faced with this murder charge. And it's surprisingly not as cut and dry as it might seem. So the jury has reached a verdict. I show that it was about 11 hours of deliberation. It's going to be just a minute here before we get the verdict here. But for felony murder to be proved, they just have to prove that Kathy Griffith is dead, and that while engaged in kidnapping, Collin caused the death of Kathy, and that Collin was the person that actually killed Kathy. I think that might be an easier one. There are some lesser includeds, including second-degree murder. We've got first-degree murder, premeditated is the main charge, second-degree murder, and manslaughter, and then felony murder is also on the table. So the kidnapping stems from altercation that was viewed by neighbors outside his grandmother's house. Susan, his grandmother. Collin basically left home and went to live there. His mom was not happy about that and was coming down to pick him up to make him come back home. When she arrived, she went in, grabbed some stuff out of the house, threw it in his car, and then an altercation took place where two neighbors reported that Collin grabbed his mom by the hair, was pulling her hair. One neighbor, through the closed doors and windows, could clearly hear Kathy say, "Collin, stop, you're hurting me." At which point they both went inside, possibly pulled in Collin still, with the arm around the hair type thing, and then Kathy was killed. Collin says that it was self-defense, that he came at her with the knife and that she fell on it. There was only one stab wound. It did go through the neck entirely and out the other side. But there's not a lot of evidence other than that as to what happened. So we're going to see if there's a lesser included. I'd be surprised if we came back with a not guilty. But once again, we are in Florida and anything can happen. Let's see. All right, we've got our hiss from court. Got 2 verdicts in one day. Did the clerk have a vote? No. Camera 3. Everybody has to be gathered in together. Obviously, the defendant has to be there. He should be in a holding cell. He's one of the easiest people to get to court. The victim's family usually has to arrive as well as prosecution and defense. And the jury is already there. They've been deliberating all morning. Lynn, yes, we do have a verdict. Let's see if the judge arrives here in just a moment. Rittenhouse was up with Judge Schroeder. In the same courtroom as Zachariah Anderson. There we go.
24 CF 8410. Mr. Griffith is present with Ms. Thornhill and Mr. Hendry. Mr. Levine is here for the state. I understand the jury has reached a verdict.
Yes, Judge.
Let's have the jury, please.
There's Collin there in the glasses between his two attorneys. The first day he was quite visible, and since then he's been positioned sort of out of view, sort of hidden from the camera by one of his attorneys, but in full view of the jury who sits opposite him in the courtroom. The way this courtroom is laid out, the judge sits on one side, the gallery sits on the other, and then to the right and left, you have, on the right you have the jury, and to the left you have both the prosecution and defense. We assume that when we hear that the jury actually has a verdict, that they have, in fact, reached a verdict and they're not hung. Who's he smiling at? I don't know. All we know about Collin is what we've been told, and we've been told that he was evaluated for his mental health condition, and that he is fine, does not need treatment, does not need medication, that he's able to participate in his case, in his defense without problems, and that legally there's no problem with proceeding with this case. They are charging him as an adult, but as he is a juvenile still, they can't pursue the death penalty in this case. The Supreme Court's ruled that that's not allowed when the age of the defendant is still in the juvenile range. So life without parole is the worst he could receive in this case, even though Florida does have a death penalty. It doesn't rule out a personality disorder. Collin himself has told people that there's Collin 1 and Collin 2, and that 1 is the one that will act out and do whatever it needs to protect Collin 1. Or Collin 2 would act out and do whatever it needs to protect Collin 1. He's going to need help.
All right, please.
Please be seated. If you are the foreperson, please raise your hand. For the record, juror number 1980896 has raised his or her hand. You may put your hand down. Juror number 1980896, if the jury has reached a verdict, please raise your hand. That juror has his or her hand raised. You may put your hand down. Please pass the verdict form to the bailiff.
We're doing a lot to protect the identity of the jury.
There are no defects nor omissions in the verdict. Counsel for the state, counsel for the defendant, rise and hearken to the verdict. Mr. Griffith, rise and hearken to the verdict.
State of Florida versus Collin Griffin. Will the jury find as follows? As to the defendant in this case, the defendant, as to count 1, the defendant is not guilty. As to count 2, the defendant is not guilty. So say will this 5th day of February, 2025.
Does the state wish to have the jury polled? You may be seated. Ladies and gentlemen, I want to thank you for the considerable time and attention you have given this case. I also want to advise you of some very special privileges you now enjoy, having served on this jury. No juror can ever be required to discuss what has occurred in the jury room, with rare exception, and that would require a court order following a fully noticed hearing. For centuries, our society has relied upon juries to consider difficult cases, and during that time we have agreed a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to have to speak about the jury's work. Although at this point you are at liberty to speak to anyone you would like to about this case, including your deliberations, you are equally free to refuse to do so. A request may come from those who are simply curious, perhaps from those who might seek to find fault with you, from the media, the attorneys, or elsewhere. It will be up to you individually to determine whether to preserve your privacy as a juror. On behalf of the entire 10th Circuit and all assembled here, I humbly thank you for your service. You are now discharged.
All rise, please.
He's nodding. Wow.
Mr. Griffith, the jury having found you not guilty in each count, you are hereby adjudicated to be not guilty in each count and forever discharged for these offenses. You will be adjourned.
I don't know what to say. I am shocked. I am shocked. The one question the jury asked was if they could have a readback of the testimony from the two neighbors across the street who saw the altercation with the hair pulling. They didn't get it, and they also didn't get they didn't get the transcript. They didn't get a readback, and they instead deliberated for another 6 or 7 hours. If the jury found that he was guilty of kidnapping, the rules in Florida, the law in Florida is such that that he cannot be guilty of the kidnapping, which was an instigating offense, and then be not guilty of some degree of murder. So it's crucial that they found that he was not guilty of kidnapping, because that made it available for the self-defense, as we see Grandma there facing us, hugging family members. It's her daughter that's the victim. But Grandma testified mostly against her daughter in this case, in support of Collin. That's presumably where he will be going and looking for support going forward. But family members are filing out now. I'm shocked. I'm absolutely, I am floored. The jury did not know. The jury did not know that Collin previously shot his dad. They knew that he shot and killed someone in Oklahoma, and they very carefully danced around the fact that it was in fact his dad. But the jury did not know he shot his dad, and now we don't know if the jury their reasoning was that it was in fact an accident, or if just the state didn't prove it. But with the way the defense argued in the closing arguments, they said that this is an issue of self-defense, which means he would have to have been involved in doing this. If he would have had to have an active part in doing that. Oh my goodness! It would mean he's killed both his mom and his dad, and he has not been convicted of either one. He's not guilty and needs people to let him go, get on with his life. If he is brought up on dad, they can use this in that trial. His family supports him. We should too. That's the verdict of the jury. I'm floored. I'm surprised, but we stand by it. I respect the system. Hope we get to hear from a juror, especially after they find out about the dad. That would be interesting if we do. The judge obviously did everything he could to to protect the jury, not even releasing the gender or the voice of the foreperson on the jury, doing by show of hands instead of by voice. Oh, wow. Larly Annie gifted 5 memberships. Thank you very much, Larly. Appreciate that. Looks like we did just hit the 1,000 likes on the stream. Larly, you've been good about that. I am I'm very, very surprised. I hope he gets the help that he needs, because as he's now adjudicated not guilty, forevermore going forward, not guilty in this case, unless there was some sort of massive, no, I don't think even new evidence. I don't think they could bring that in. He still needs help. Collin grew up in a very rough childhood. Witnessing his mom attacking his dad, pinning his dad to the wall with the car, attacking him with a corkscrew, witnessing people in states of self-harm with firearms. It was rough. He needs some help. He needs a lot of help, and I hope he gets it. I hope he gets it here. Wow. We don't know all the facts. What we do know is Oklahoma is reopening the investigation into the cause of death for his dad, presumably because there was information raised in this case that calls into question whether or not it was self-defense or not. So there may be another trial in Oklahoma. There may be charges. He was charged. He was arrested but never charged in that case. There may be charges coming down the road for that, but I'm not sure. Now the jury's going to find out about Dad. I don't know if it'll make a big difference. They knew there was another person. Wow. Where's he going to live now? He's nearly an adult, and I believe he does have a trust fund, possibly from his dad, from the death of his dad. You guys, this has been a absolutely crazy week in court. I'm blown away. This is wild. I'll be talking about this trial tonight with Courtroom Confidential on their channel, the Collin Griffith trial, and I'm going to have to mull this over a little bit before we talk about it. But I do hope that you give that channel a subscribe and then come join us live tonight as I talk with Josh about this. Can he get the death penalty in Oklahoma if they charge him when he's 18? I don't think they can retroactively charge him with the death penalty. It would be at the age he was, because you're judged based on what you knew at the time, right? And so the age he committed the crime, if they determine it was a crime, that would be. So I don't think death penalty would qualify for that, Gabby. Great question, though. Yes, please do subscribe to Courtroom Confidential and tell Josh Ritter that he sent. I wish I could play this. Speaking of videos. Oh, the video is unavailable. Man. Quilt Lizzie. That's funny. All right. Anyway, I love my hometown. I've got some great people here. I was going to share something funny on their channel, but Josh is great, has great content. You're absolutely right. He does. I'm honored and privileged that he would consider me to be a guest on his show.
Call from Master Ayden.
Master Ayden, how are you doing today?
I'm doing okay. I'm a little blown away like you. Was not expecting that verdict.
It feels like a Casey Anthony moment. Just a little bit.
It does. It almost makes me afraid of the new case that we're dealing with the child unaliving. Yeah. Ironically, in Oklahoma City, I have an adopted brother that was charged and convicted with murder, and he's currently serving life in prison. Oh, so it kind of, yeah. It was on Super Bowl day as well, 2 years ago, I want to say.
Man. Sorry to hear that. This is...
yeah.
You want to be in the mind of the jury. Obviously, we got to see what they got to hear, but we also got to hear other things. And maybe that tainted us. maybe that pushed us in the other direction, and that's why rules of evidence are what they are, because they were
That's exactly
too
right.
prejudicial, right? When we
Right,
heard that he
right.
killed his dad, we're like, well, and now he's gone after his mom. And so
Right.
maybe the judge was right in saying, you can't bring that in. And the jury got to look at this
No.
in a more isolated situation. And I think clearly they decided that, most logically, that there isn't evidence to prove that he did it, and that it could have been an
I
accident.
think that's what it came down to, right? I think because of the paint, the picture that was painted on the mom also may have weighed in on the jurors. She wasn't painted in the best picture on either side, and so it was kind of like, well, maybe an altercation ensued. Maybe I don't believe she fell in love, but maybe he felt threatened at the moment and decided to act on it.
Yeah, and
that's kind of where I'm with.
And it's a tough case to watch when they litigate like this, because a lot of the court case people are saying this is victim shaming. Okay, this is victim shaming. You're making her look bad. She's not here to defend herself. But the flip side of that is she's not the one on trial.
She's
Collin
not.
is.
No, she's not. Yeah.
And so, as ugly as it sometimes looks to hear, everyone's darkest moments and poorest moments as a parent, presented in front of the court, that is the law. That is something the jury is allowed to consider.
Opinions are opinions. Yeah, exactly. Opinions are opinions, but the law is the law. I thought they was gonna. When he was smiling at the computer screen, I was like, "There's no way, you can kind of muster over that." I mean, he was smirking. He didn't seem like he cared. And then I 100% think that they knew that they were talking about the dad. I mean, people say jurors follow the rules, but I'm on the line of they watch. No.
I cannot believe that. In my mind, all jurors follow all the rules, except for just a couple exceptions, and we always catch them if they don't. So.
This is true. And clerks follow the rules too. I'm with the clerks.
All the clerks follow the rules as well.
Right. They don't get involved.
No, this does. I don't know. I think this case feels wrong because it shouldn't have happened. Right. This was preventable. This is one of those situations, a lot like what we're seeing in Tennessee now with Megan Boswell. It should never have gotten to this point, and so it feels wrong to even be here, right? Because the facts that led us here we should have been caught ages ago, miles back before we took this exit. We should have changed course. And
there's red signs everywhere. Yes.
Yeah.
Lack of responsibility leads to things like this. But with that case coming up, it's very hurtful to me, and I'm glad you're putting it on there. I know some people are like, why? But you have to show the world for what it is. It's court. It's reality. It happens, and for me, having two little ones, it's gonna hurt, but I'm gonna watch it. And I'm very depressed about my blindness. It bothers me every day. But in this case here, I'm glad I can't see those pictures, because I don't know how I would react. I'd break down at work if I saw those pictures. Yeah. It would totally mess me up inside.
Yeah. Crazy. Master Ayden, thank you very much for the call. Appreciate you sharing your insights.
Thank you for receiving it. Okay, thank you.
We'll see you. Bye.
From Marley.
Hey, Marley, this is RA. You turn your video down just a little bit. It'll be a little confusing.
I just turned it down.
Awesome.
Is it better?
Excellent. How are you doing?
I'm doing good. It's my first time calling in, but I've been watching you for about a year. Thank you so much for what you do.
Well, you sound like a pro. You sound calm, cool, collected. What's on your mind today?
Well, I am blown away like everybody else, but what keeps coming to my mind is I think the jury, all the threats that he made about murdering his mom and how he was going to do it to the police, to his dad, to anybody who would listen, that maybe the jury looked at that like that was his cry for help. Like he told everybody how he felt. He warned them, and nobody listened to him.
But that doesn't take away the guilt factor, right? Whether or not he's guilty.
I'm trying to figure out how the jury came up with what they did come up with.
It's got to be.
And that's the only thing I can think of.
It's got to be that it, in fact, was or could have been self-defense. I think it would probably be easier for me to think the jury thought that it could have been self-defense and had that room for reasonable doubt because they did have evidence that his mom had possibly at one time pointed a gun at herself or at him, had threatened to end her life or his, had taken actions that could be lethal if they had gone wrong against other people.
Absolutely.
Had all these issues and baggage, and we heard the tapes, those ring footage from her house, her own voice, and she was doing it to preserve her side of the story, but at the same time it painted a picture of her that wasn't flattering.
A maniac, yes.
Yeah, and almost, I mean, you're looking at, you're wondering if there's some sort of bipolar, some sort of mental health situation that was at play there, and I think that was enough, along with the defense just saying it could have been this other way. And just look at the evidence. We're not fabricating something out of whole cloth here to say that the mom could have attacked him. That was actually in the realm of possibility, and that must have resonated with the jury, at least to the degree where they said, where I said, I think he did it, but I'm not sure the state has gone enough to prove that it wasn't any other thing, and there's room for reasonable doubt.
And the sad part is didn't they say that he's got no psychological issues, so he doesn't need any kind of treatment or anything?
Yeah.
So how is he really going to get help?
Well, I hope he does. I hope he does, because it might not be a diagnosable condition, that's in the DSM-5, but nobody goes through life and through the experience he's gone through that doesn't have some baggage and some mental issues they need to work through, and have somebody on the outside help them work through. I've got one more call coming in. Is there any other thoughts you have?
Okay, thank you so much. I appreciate you. Thanks for all you do.
Thank you. Bye-bye.
All right. Bye-bye.
Call from Megan.
Megan, this is R.A. How are you doing?
Hey, R.A. I can't believe the verdict, but I get it. I kind of get it.
It surprised me. I mean, I told you that I was not quite on the guilty side yet. I wasn't sure if the state had room, but I thought he was more likely did it than not.
Right.
And that moment in jury instructions when they said that if you find that he was guilty of kidnapping, then self-defense is off the table. I'm like, that's huge. This is very important. They found that he wasn't guilty of kidnapping, which kept self-defense on the table, and that made this all possible. What are your thoughts? What are you thinking on this?
My thoughts automatically went back to the father to say, are they paying attention to this? Are they going to look at this and then be like, we need to re-examine his case, the case with that. Yeah. And if they do, and they, bring him back to Oklahoma, are they going to say, well, you can't say anything about the mom's case because he was found not guilty?
They wouldn't bring up. I think they would. First of all, they would probably have the same rule, but they might even go a step further to say you can bring up that he was charged, but it was ruled that it was that he was not guilty in that case. I think they would bring it up. Defense would want that. But the only thing they would bring to Oklahoma from this trial, if there was something, would be evidence that we did not see. And that would be the ring camera footage of a confession of some sort to say, Collin stating that it wasn't self-defense. And we don't even know if that exists. Defense in their statement to the jury at the end of the closing argument said, you've heard about this. And she said, I'm going to send these videos here and there. Don't you think if they existed, you would have heard them?
Right.
And we didn't hear them.
Right. And my other thought is he did a lot of Google searches, Ted Bundy, different things, and
none of that came in. Not at all.
Right. But it's scary because does he think he's invincible now?
Well,
like, is this a serial killer in the making? He's like, I can get away with anything.
I know there's some people who feel that, and they're looking at this and saying, grandparents, be careful, be alert. Obviously, this this young man, now an adult, right? He's basically 18. Is he 17 now or 18?
Yeah, 18.
He's had some pretty tough experiences that could.
I totally get. I mean, you could see it with the videos of the mom, and she was all over the place and sideways. And of course, we haven't heard anything good about the dad. It just sounds like a very unfortunate family dynamic, right down to the grandparents. You know,
it's been less than ideal for generations.
Right.
And problematic, and it's sad.
Right.
That was probably one of the saddest parts of this trial, is to hear how generations have dealt with sort of dysfunction.
And yeah, exactly. And like you had said earlier, it's like, as far as him getting help, I hope he would be receptive to that. But since he is quote unquote an adult, he may not seek that on his own, nor heed anybody's, advice on that.
Yeah.
Which is sad. Because, if you let stuff like this go on too long, it has a tendency to repeat itself. Whether he never has another incident again, but he could get married, have children, and exhibit the same things that his parents did to him onto his kids.
Yeah. We know that the grandpa doesn't like him at all. Grandma does. That's obviously going to put some stress on the family relationships there. But going forward,
well, I
hope he gets
isn't
help.
She divorced from
I think they
grandpa?
did divorce, but I mean,
Yeah.
he's still grandpa. It's still, the bloodline still goes there. But,
right.
Man.
All right. Well, that's my 2 cents. So,
wild,
but
wild
still
day.
kind of crazy. I thought maybe a lesser charge, but
I was thinking it would be a compromise verdict as well.
Right.
But, wow.
Okay. Well, thank you.
All right. Thank you. We'll see you.
All right. Bye.
All right. Sorry, the phone is buzzing busily. We're trying to get all the calls we can to get your viewpoints here. Amber, you're the only one whose name doesn't get announced. I don't know how you get through my system without your call is the only one that doesn't get screened, and I don't know how.
Look, Greeners has his way with the internet. I have my way with the phone calls.
You'll never reveal.
Nope.
What are your thoughts on this one?
No comment on that, but I did put something in my chat that you might want to look at and bookmark.
Okay. No comment. Let's see.
I just gotta see you. I just gotta see you pull it up.
Okay. Hang on. Sarah Boone?
Greeners.
Hang on. What? Don't time out Greeners. He's being good. What did Sarah Boone say?
He is not being good.
I'm trying to see what this is. This is a docket date for Sarah Boone of.
It's the appellate link to her entire case. So bookmark it.
6th District Court of Appeals. Right?
Mm-hmm.
Why would I bookmark when I have a mod who will just send me the link every time I ask?
You know what?
All right.
I'm calling Mrs. already.
All right. I'll try to figure out how to bookmark this. Send it to me as a text message, not in mod chat, because I'll lose this.
Oh my gracious. Okay.
Yeah. Thank you, Amber. Appreciate it.
You're welcome.
Bye. I have to say thank you to my mods. We have the absolutely best mods ever. They help me more than I can even explain. Not just in chat, keeping things nice and copacetic when a troll pops in and decides to spout off whatever they want to spout off, but helping me on the back end. That would be good. Let's see. Who is Greeners? Greeners is a longtime supporter. He's right here. He's normally just Greeners. Right now he's Greeners in Gitmo because Amber added him to the map in Guantanamo Bay. But Greeners is a longtime supporter, longtime listener of the channel, and somebody who has impeccable comedic timing in chat. All right. A lot of people saying this is a bad thing and that the events will repeat themselves. I don't know, but yeah, I'm surprised. But I told you I told you through the get-go, I'm not sure if the state has ruled out that reasonable doubt to prove that it couldn't have been an accident. But, all right. With that, here's where we are. Today we've had two verdicts. We've had a verdict, obviously, just now in the Collin Griffith case, surprise not guilty on that one, on both counts of kidnapping and first-degree murder. And we've also had a verdict in our bus case out of Thurston, Washington, which we started yesterday and ended this morning. That case got crazy. I think there's more to be heard out of Thurston, Washington about that. So we'll see how that develops. But two verdicts. Now we just have one more.
From Becky.
One more trial to watch here in Tennessee versus Megan Boswell. Becky, how are you doing?
I'm doing good. It's nice and cold here in Kansas.
Oh, you can keep it. It's beautiful here. I'm wearing shorts and short sleeves. It's actually rolled up long sleeves, but
I like that. Well, let me tell you, I'm not surprised. I'm really not.
Not surprised that they're not guilty?
Yeah. I didn't think that he would get it, but I kind of, in my mind, if I'd been on the jury, it would have been not guilty.
Yeah.
And it's because of all the history and all the times he asked for help. He was an abused child, and he was acting out, and he was asking for help, and the ultimate happened. It was bound to happen sooner or later.
Yeah. Well, the jury agreed in one way or another with that because they returned a unanimous not guilty verdict, and a big relief and smiles from Collin. So.
Yeah. I bet. Can you imagine? I mean, he was looking at life in prison.
Yeah, it's amazing. I've got to think this one over. Obviously, we've got the live stream tonight with Courtroom Confidential, and we'll be talking about this trial. And
I'll be watching. I'll be watching. Be fun.
Well, thank you. And
I have a different point of view.
Yeah, thank you, Becky, and hello to Kansas. It's good to have you check
in.
Thank you so much. We'll see you.
Bye.
Bye. Oh. Interesting. Trying to look at chat here. I know chat's going crazy, and I apologize. I'm not able to keep up with everything that's happening here. Thank you to the mods.
Rage Crochet.
Rage Crochet. We've seen you in chat a couple times today. How are you doing?
Good. How are you?
Doing good. Happy hump day.
Yeah, finally. It's nice.
What are your thoughts on this case? You just want a deep breath and just have some quiet? Because we can do that as well. I can play some soft, quiet music.
I agree with the jury. I'm probably in a minority, but I agree with the jury. But mostly because of reasonable doubt for me, at least on the murder one charge.
Reasonable doubt on the murder one. What about the kidnapping?
I just didn't see it. I just didn't. From the, one neighbor saw him kind of leading her inside or grabbing her or whatever, but the other one didn't, and I just didn't.
Yeah, one neighbor didn't describe her being pulled in. She described that they went in. But interesting. I thought that the kidnapping one was almost a for sure, but that's why I thought it would be a compromise verdict, because that would eliminate self-defense off the table for the jury. But it seemed like the instructions, the elements of the charge of kidnapping were easier to reach based on the evidence that we had than the first-degree murder. But
yeah, that's for sure. Yeah, I was just really surprised. We don't see a not guilty on across the board very often.
Yeah, we got two today.
Right.
One in an almost inconsequential case. Obviously, it's a big deal to Mr. Little, but this other one in a national, high-profile case that I think has left a lot of people shocked.
Yeah, definitely. Yeah, I mean, I'm shocked, and I've been watching the whole time.
Man, that is wild. Where can I ask? Where do you hail from? Where's home?
Wisconsin.
I couldn't even detect the accent.
Yeah. Oh, thank God.
have you tried to lose it?
I do try, but in my own streams when I'm watching them back once in a while, I can definitely tell when I'm a little more excited or talking fast. But I do try.
Well, we'll have to get you fired up so we can hear the accent again. So, thank you very much. Any other thoughts you wanted to share on this case?
No, I think we all just need to remember that the jury is the jury, and we are chat.
Yep, it is. I do believe in supporting the verdict of the jury. I have faith in the system, right? It's not a perfect system, and it doesn't work every time, but I can't think of a better one out there or how to make the one we have any better than what we have. And so the least I can do is support the system, even when it works a little bit differently than I think it should. But,
yeah, exactly. We have to. I mean, it's our country. We have to support what everybody before us has concluded is the best way for our country.
iRescue Dog says Wisconsin doesn't have an accent. So
I tell people that too until they call me out on it.
I heard a little bit and they call you out. It's almost it's like a soft Canadian accent is what it is.
Yeah, very. So. Don't talk to someone from the UP, and then they have a way worse accent than we do.
Yeah. Awesome. Well, thank you very much. Love talking to you. Please check in again. We'll see you in chat.
Yeah, we'll do. Have a good day.
Yep. You too. Bye.
Yeah. Bye.
All right. If you guys are ready to be done, we know the jury that's sequestered in the Tennessee case is done as well. They're back at the hotel. They'll be resting. We're going to be back early in the morning, about 8:30. To pick up the Tennessee versus Megan Boswell case. That trial is, I think, you're going to pick up with a bang as the judge decides a crucial issue that may allow the defense to have everything Megan wants to tell about the case presented to the jury without her taking the stand. And I can't stress how big a deal I think that is. That is huge. That is all the benefits of testifying with none of the cross-examination. It's crazy, but the judge has to make the call. Right now, the judge is back in chambers watching 2 hours of interrogation, which we may end up watching as well tomorrow, and we'll see what happens. It's going to be a absolutely crazy week. I appreciate everyone in chat. I realize we're dealing with some hard issues in all three of these cases we've been talking about. Well, not so much in the bus case, but in the other ones. Thank you for being respectful. Thanks for bringing your commentary and your insights and sharing them in a way that adds to the conversation, that enlightens and informs and lifts the conversation, makes us all better. I appreciate you doing that. This community could not function unless you did. That makes very little work for the mods, which is good because they have plenty of other work to do. And it makes all of us a little better off, and it makes the environment one that you'd want to come back with. And I'd ask you to. Please do come back and watch tomorrow as we start the Tennessee case again in the morning. So tonight I'm going to be on Courtroom Confidential, 8 p.m. tonight. That's going to be live with Josh. It's going to be awesome. Everything I've done with him before has been taped, but hasn't aired yet. So do go over there, click the link, subscribe, ring the bell, and I'd love to see you in chat as we have a brief conversation about this very case. And I'm going to try to organize my thoughts into something somewhat coherent because my brain is scrambled after this one. It's crazy. It's absolutely crazy. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tonight on Courtroom Confidential at 8 p.m. After that, we'll be live tomorrow morning at 8:30 or 8:15, right around there, as the case continues in Tennessee. You guys have yourselves a wonderful day. Be good to each other. We'll see you.
scratch all that. Oh, that was terrible. I apologize.